A recent Supreme Court decision has many prosecutors concerned about the possible impact on cases in Virginia. The Supreme Court ruled in the Melendez-Diaz case that defendants have the right to face their accusers, such as lab analysts who process drug information in cases. In Virginia, the lab certificates are provided in the case, and the lab analysts have not been required to appear. Some prosecutors feel the state will not be able to furnish the analysts and are calling for a special session of the legislature to fix the problem. Joining us now to discuss the issue is Thomas Knoll, an assistant Commonwealth attorney for Augusta County. Thomas, thanks for joining us.
Thank you for having me.
Now, what happens in Virginia drug cases, and what exactly would you assess the problem as being?
Well, what happens is, of course, the law enforcement go to the scene of suspected drug activity. They seize drugs. Those drugs are then stored at the sheriff's office for a period of time and then sent off to the forensic lab. The lab then, at some point, analyzes what's sent in and then sends out a lab to our office indicating what was found. And we later then file that with the circuit court 7 days prior to a hearing. And that's the process of how the drugs get to the lab and how they come back.
So what I guess what the defense attorneys would want, and what the Supreme Court says the defendant has the right to, is to say, okay, let me question that accuser, which in a sense is the lab technicians who's saying, indeed, what was found was cocaine, correct?
That's correct. And the way that things have been working in Virginia, there is a statute that allows for the lab to come in absent the analyst. The defendant has always had a right to subpoena the analyst if he or she wanted that person at trial. But as the Supreme Court says, it's our duty to have the analyst in court if the defendant asserts his right to confrontation, which is confrontation with that analyst to cross-examine about what he found that he was testing.
Now, I guess the big problem is that it sounds like there's not enough analysts to be running to court every time someone wants to question the analyst about the case.
Well, it's hard to say at this point if we have enough or not. What we do know is that we have never had to have the analyst always available for all of these drug cases. This is a new procedure for Virginia, and at this point it's a little bit early to know how that's going to impact us. We do know that it would certainly at this stage send the analysts back and forth to many different jurisdictions, unlike they have done in the past.
Has this affected the cases in Augusta County to this point?
You know, this decision was handed down at the end of June last month, and what it has done for our jurisdiction at this point is we have had to continue a few of our drug cases because we certainly weren't prepared at this late point in our trial process to have an analyst available because we've never done it before in the past.
What about other states? How do they deal with this?
What other states have done, and this is cited in the Supreme Court decision, they have done what's called they have made a notice and demand statute, which allows the prosecutor to inform the defendant that they intend to introduce a lab absent an analyst, and then the defendant is given an opportunity, a short window in which to object to the lab coming into his case without the analyst, or to waive that right at that point. And that's what other states have done to address the Confrontation Clause issue brought up in this Diaz case.
What would you say would be the way to fix Virginia law?
The easiest is this notice and demand, because then we know at least the defendant knows what we plan to do with the lab, and then we are given notice of what he or she wants to do with what we seek to introduce. And I think it's more efficient that way rather than at this point raising it a day or during trial.
So this would just have to be changed at the legislative level?
Yes, exactly. And as the decision in Diaz referenced, this type of notice and demand statute to address this very problem would correct and deal with the Confrontation Clause issue.
All right, very good. Thomas Knoll, an assistant Commonwealth attorney for Augusta County, thanks so much for joining us.
Thank you for having me.
And now let's send it back to Mel